This particular training, the timetable is 12 weeks, and we're already on week 10. Today starts week 10. Each topic is taken throughout the whole week. So we have 2 more weeks to go after this week. Then we will come to the end of this first batch of training for the year. Take a few days break. We start again from the beginning. So we hope to see more of you, and with time, have your other colleagues join the training. Thank you and welcome once again. So, gentlemen, today we are discussing law reforms and law reformers. Like I said earlier, today is day 46 of the 12-week training, and today begins our week 10. The law reform process and legislative drafting is the title of this week's training, and under this we shall look at subheadings such as law reform process, law revision, alteration of constitution, consolidation of laws, codification, indexing and gazetting of laws. In the context of legislative drafting, the law reform process involves identifying areas needing improvement, conducting research, consulting with stakeholders, formulating recommendations, and ultimately proposing and implementing changes through legislation or policy. This is distinct from mere revision or consolidation. Now we have a more detailed breakdown of the law reform process in legislative drafting. They are as follows. 1. Identification of issues and need for reform. So we look at problem identification. The process begins with identifying areas of law that are outdated, 1, ineffective, 2, or causing unintended consequences. So if you are doing your problem identification, you don't just wake up and say, let us reform. What are you doing? You look at first for areas of the law that are outdated, that are no longer serving the current level to which the society has transformed. So the law is outdated or obsolete. 2, areas of law that is ineffective or that are ineffective, or areas of law that are causing unintended consequences. When the drafters drafted the law, they didn't foresee that as a consequence. So it was not in their contemplation. But due to interpretation of the courts of the laws, due to trying to apply the law, we now have these unintended consequences. So what do? We reform. We note that as possible area of reform. Review of existing laws. We have done problem identification. Next is review of existing laws. A thorough review of existing laws, regulation, and case law is conducted to understand 1, their purpose, 2, their impact, and 3, any shortcomings. So in reviewing existing laws, we are looking at for 3 things: to understand the purpose of that law, 2, the impact of this law. Is this making the desired impact? 3, are there shortcomings? So the last one is stakeholder engagement. Now, these 3 are under identification of issues and need for reform. We do problem identification, we do review of existing laws, then stakeholder engagement. Early engagement with stakeholders, including government agencies, legal professionals, and the public, is crucial to understand their perspectives and concerns. Unfortunately, most times, once laws are passed, we do not do post-legislative scrutiny to see whether this law is being implemented the way it was envisioned in the minds of the legislators. So this is where post-legislative scrutiny comes in. You engage, find out whether this law is achieving the desired purpose. Then 2, research and analysis. Data collection, 1. Gathering relevant data, including legal precedents, economic data, and social statistics to inform the reform process. You do not just reform in a vacuum. You do not reform because it is time to reform. That reform will just be an exercise to fulfill all righteousness. It will not make impact. But in carrying out a reform, you need to do research and analysis. It is in doing this research and analysis that you collect data, 1. 2, you gather precedents for comparison. Then economic data, how is this law affect, what's the impact of this law on the economy? Then social statistics, what is the impact of this law in our society? Now, when you gather these statistics, you now see the need to reform, and your reform will be guided by the data you have collected. Then comparative analysis, examining laws and legal systems in other jurisdictions to identify best practices and potential solutions. Three, impact assessment or examining laws under comparative analysis. What you do is you get your own laws, you compare it with laws of other nations or other jurisdictions, similar laws in other jurisdictions. How does their own law apply? You remember some time ago, we talked about the principle of functionality or the functionality text to show that, okay, this thing, the way it is functioning in Ghana, if we transplant it to Nigeria, will it also function? Putting into consideration a lot of factors from our cultural belief system to our religious belief to our existing laws to our mechanisms of implementation. All those factors together. It's not just enough to copy and paste. So in your comparative analysis, you pass it through the functionality test. Yes, this is how it is done in the UK. But if we brought what is in the UK to Nigeria, beyond putting it on paper, will it be functional in our society? If we answer that question in the affirmative, then we can import that procedure. But after careful examination, if we answer that question in the negative, there is no need of importing. But comparative analysis helps you to see what is obtainable in other jurisdictions and see how they are making progress, and you see what you can borrow from them to enrich your own law. Then, impact assessments. Conducting impact assessments to evaluate the potential consequences of proposed reforms, both positive and negative. Now, what we are dealing with is the ideal procedure, the ideal process. But whether this ideal process is followed in practice, in reality, is a different ballgame. Now, impact assessment is important because it's not about making a law. What is going to be the impact, positive or negative? So, in way, more like cost-benefit analysis. When you do your impact assessment, you now know, okay, does the positive impact outweigh the negative impact? Does the negative impact outweigh the positive impact? Based on that, you can make an informed decision as to what reforms you can make in that particular law or regarding that particular law. Then, formulation of recommendations. Drafting proposals. Based on research and analysis, draft proposals of law reform are developed, outlining the proposed changes and their rationale. Then we have consultation and feedback. The draft proposals are circulated for public consultation and feedback, allowing stakeholders to comment and refine the proposals. Then we now have that. This is more like where we usually have our public hearing at the committee stage of lawmaking process. But this is a replication of that. Then finalization and recommendation. After considering the feedback, the final recommendations for law reform are prepared, outlining the proposed changes and their expected outcomes. Then we look at implementing and legislative drafting. One, legislative drafting. The recommendations are translated into legislative language, ensuring clarity, precision, and consistency with existing laws. If we are doing a law reform, you are not bringing something radically different from the existing law. Rather, you are improving on the existing law. So in doing that, you do not discard the existing law, no. You must also avert your mind to issues of conflict. So while you are drafting, you ensure that there is no conflict between the reform you are bringing and existing laws, particularly the Constitution, and even other laws on the subject matter of reform. Then we look at policy changes. In some cases, the law reform process may lead to policy changes rather than legislative amendments. So, policy changes is done at the executive level within the ministries. So, if you recall, we talked about subsidiary legislation last week, now or 2 weeks ago. If in the course of your analysis you discover that there is really no need to amend or to reform existing laws, you can resort to policy change. Okay, we from this law we derive this policy, we derive this policy, we derive this policy. Now, don't forget that from the executive, it's actually the policy that eventually becomes law. So once you notice that this law has achieved the desired goal, from that same law, you can look at how you can extract other policies, leading to policy. In some quarters, they call it policy somersaults, or policy changes, still leading to the realization of the law. Then parliamentary process. The proposed legislation or policy changes are then introduced to the parliament for debate and approval. Implementation. Once approved, the new laws or policies are implemented and enforced. So you notice that law reform, you are not making a new law per se. Even though in some cases there might be need to remove, we said you are looking at obsolete laws. You are looking at laws that are no longer serving the societal, the level to which the society has evolved at the moment. So in doing that, there might be need to edit. There might be need to consolidate some laws. There might be need to add in some areas. That is where those ones we have to go through the parliamentary procedure of lawmaking, because they are leading to amendments. But where it does not get to that, you will have just codification. We will discuss codification separately. You just have to do consolidation. And what is consolidation? Bringing all the laws that are under the same subject matter as one volume for ease of access. Maybe you have different health laws, different tax laws, different laws on petroleum, different laws on maybe transportation. So consolidation now brings all the laws on health together as one volume or compendium. So if you are talking about health laws of these states, once you pick that compendium, you have different laws, the laws on primary health care, the laws on tertiary institutions, the laws on healthcare funding, different laws under that same compendium. So that is consolidation. Whereas codification, on the other hand, is bringing into existence, for example, our customary practices. You know, our customary practices are not they are not codified. They vary from place to place. It is just the practice of the people, pension of the people over time, handed down from generation to generation, mostly through oral tradition. So at a point something happens, they say, my father said this. My father said that his grandfather said, when this thing happened, this is how they did it. But codification now means, okay, we want to codify the customary law of the Gbagi people of FCT, Abuja. So what is the procedure of marriage? We now have it written down as laws, such that if you want to do dissolution, so we also say what is the procedure for marriage, we have it. What is the procedure for dissolution, we have it. What is your procedure for proving paternity? What is your procedure for, we have all those customarily, but we have it written down and passed by the house as a law. Once that is done, that is what we call codification. Now, this codification in common law is different from codification in civil law. Civil law, their laws are generally written in codes, but in common law, it is not. When we talk about codification of laws, is making our customary laws in permanent form through writing them down and passing them. So that gives us more like standardization, one, and certainty of customary law, such that when you go to community A, where there used to be slight variation, we no longer have it, provided that they are within the same locality. So that is codification of laws. Then indexing and gazetting of laws. You recall that when we talked about the process of lawmaking, the final process is when the president assents. That is when it becomes a law, or when the governor puts his signature, it becomes a law. But after that, the law, by the provisions of our Acts Authentication Act, that law is supposed to be produced in triplicates. A copy goes to the CJN for enrollment. A copy goes to the CNA, the clerk to the National Assembly, for numbering, and that is where this thing comes in, indexing. Then a copy goes to the AGF, Attorney General of the Federation, for gazetting. Now, gazetting is the process of official production of the laws of the Federation by the office of the Attorney General. The official copies, the official printed copies. A gazetted law is supposed to have I think the national printer or the printer for the federal government is in Lagos. So you will have Federal Republic of Nigeria official gazette. Then they will put the dates of production. That process of gazetting, if that law you have is not gazetted, it might not be the original copy. It might not be recognized. So, and if you recall the case of Igoro versus University of Lagos, we talked about that case last week. The court held that for a primary or for a subsidiary legislation to become to have the force of law or have a binding effect, it has to be gazetted. If it is not gazetted, then it does not have the force of law. So every law has to be gazetted, meaning giving public notice of the existence of that law. Where that is not done, the law lacks the force or power of enforcement. Then indexing is the serial alphabetical arrangement of all the laws of the state for the purpose of ease of identification and accessibility. So once you have an index, if you are looking for maybe laws that start with letter M, maritime law, for example, Marriage Act, Matrimonial Causes Act, so military laws, if you are looking for that, they are alphabetically arranged. These are the laws of the states that we have. Okay, after ALDRAP did a job for Rivers State, and in that job, we collated all the 134 laws of Rivers State, putting it together. Now, the indexing of what we did a law review job for them, but the index of that, once you look at it, more like table of contents, as you look at it alphabetically arranged, you know all the laws all the laws are listed there. So as you're looking, any law you are looking for, you know, okay, this law starts from F. Straight, you go to letter F. Then you see all the laws that started from letter F. Okay, Lesasi, permission is granted. Permission is granted. You may go. Thank you. So that's what indexing is. And what is the benefit of indexing? Firstly, it helps you to know, to have an eagle-eyed view of all the laws of the state or the nation. One. Two, it helps for ease of identification. Three, when you want to do cross-referencing, if you are drafting and you want to know, has any law been made on this subject matter within the states, it helps you to easily check and know, okay, yes, we have a law on this, we have a law on this, particularly when you are comparing your state with another state. So that is it for indexing. Now, do not forget that the CNA has the responsibility of numbering the laws of the Federation. So this is 2025. Maybe we are still in March. Maybe the National Assembly has passed 4 or 5 laws, for example, 2025. So the numbering, the CNA has that responsibility. Okay, if he's numbering, I wouldn't know his initials, but if he's numbering, let's say, starting from, let's say he abbreviates NA 00, okay, NA National Assembly Act 001, 002 2025, 003 2025, 004 2025, till all the laws that we passed throughout this year. It's still the same for the same reason: ease of access, ease of identification, to know the number of laws we have so far. So, any question on law reform? Question? Any question? Hello? Any question? I have a particular question I am expecting. Any question? If nobody asks that question, I will ask it.
Hello,
Hi.
Ebenezer.
Yes,
This is
please.
Lungile here. I didn't hear, maybe my network wasn't good. I didn't hear number 3 or alteration of the constitution. Did you talk about it?
Good. Alteration of the Constitution. One, the Constitution is a special document. A special document in the sense that it is the ground norm. It is the highest law of the land and the number one law of the land. Each constitution puts in it the procedure for altering it. For our own constitution in Nigeria, the procedure for altering that constitution, there are 3 different areas of the constitution that we attract different processes for altering. Generally, the National Assembly initiates the constitution alteration process, after which, if it is agreed to and they succeed in doing their work, the states have to now approve. State houses of assembly have to now give their consent. 2/3 of the state houses of assembly have to now agree to say, yes, we vote in favor of the constitution alteration. If that is not done or achieved, the constitution will not be altered. That is step 1. Step 2, within the National Assembly, when the bill for constitution alteration comes and they need to give a vote of 4/5, 4/5 members to vote in favor of the alteration. If that is not achieved, the constitution will not be altered. If you are altering chapter 4, fundamental human rights, you need to get 4/5, 4/5 votes in favor of altering that chapter. So it is not just that, okay, I want to alter the constitution, those in favor say aye, those against say nay. So constitution alteration is not where you use voice votes to get your approval, because the constitution sets out number 4/5 votes, not just members present and voting, of all the members of the house. So you do not say, okay, we are 20 members were present, so we have 4/5 of members present and voting. No, it is 4/5 of all the members. Now, this is different from what obtains in Ghana. We talked about comparative analysis. Our own constitution in Nigeria does not make provision for referendum, citizens' participation. But Ghana, their constitution makes provision for that, saying that for there to be an alteration of the Ghanaian constitution, there have to be referendum by the people saying yes. Now, not just everybody in Ghana, eligible voters. And that referendum is also conducted by their own election body, electoral body. So their referendum says, their own constitution says you have to have eligible voters to vote, like 40%, I think. I will get that number correct. 40% of eligible voters must participate in the referendum, and up to 70% of those participating should be in favor of alteration of the constitution before their constitution is altered. Don't forget I said every constitution puts in it the procedure for its alteration. Now, that is not the same with every other law. That's why I said the Constitution is a special kind of law. One, it is the ground norm, meaning that it is the highest law of the land. So each Constitution puts in it the process of alteration. And our own, you must have 4/5 votes of all members of the national parliament or National Assembly in favor of the alteration process. Now, when the House have done their own alteration process, they need to get 2/3 votes of all the 36 state houses of assembly in favor of the process. So if any of these procedures fail, the constitution cannot be altered. You have to follow this process. And the constitution also has, like, if you're altering and you want to tamper with section 9 of the constitution, which is the alteration process itself, you have to get 4/5 votes in favor. If you want to touch section 4, chapter 4 of the constitution, fundamental human rights, you have to get 4/5 of the votes of members in favor of altering that chapter, not just altering the constitution itself, but altering that particular chapter. So I wouldn't know the constitution alteration procedure of your own constitution in Lesotho. So you will have to educate us on that. What is the procedure in your country? What does your constitution provide? Because every constitution provides its own alteration method. So there is no standardized procedure globally that this is the way constitution is altered. No. Each constitution provides its own alteration procedure. And where any of those processes is omitted, or the assembly decides for whatever reason not to follow that procedure, the court will annul that alteration process. Any other question, please? Any other question? Hello, any other question? Okay, I said I have my own question that I am going to ask. We read out law revision process. We have people here in ministries of justice, so of different states. So I am going to ask them. We also have people here in law reform. Madam Lungile, you are in law reform commission. Please tell us your own process of law reform. Is it the same with what we discussed here? How do you do your law reform?
Yes, it's still the same like you've been mentioning. What I'm not sure is about this National Assembly voting 4/5 thing. I'm not sure.
No,
I don't recall. Maybe I
that
just.
one is constitutional alteration. It is different from law reform.
Okay. Yeah, for law reform, all the procedure seems to be the same.
Okay.
But
Now let
here in law reform, we have two departments. We have research department, which I mean, and then we have a law revision. So I'm not familiar with the law revision procedure, but all I know that we have these indexing books in our office. So I'm not sure about the procedure.
okay. What I want
Yes.
to ask is, do you people do stakeholders engagements? Do
Yes,
you
we
people
do.
do data
We start by
collection?
doing this thing, the proposal.
Awesome.
We do the proposal. After the proposal stage is when now we identify the stakeholders, the relevant
Okay.
stakeholders concerning the subject that we are embarked on. And then thereafter, then we form a stakeholders committee, a committee. So we have to meet not every month, but we decide when to meet. What I can say again is that the stakeholders is among it's within the ministry, the Sutu ministries.
Okay.
So we meet on the time agreed upon to discuss some issues. And then after that process, is where we start by doing even our text research first, so that we can start by looking for the issues. Sorry, there's a phone here. Yes, sir. Please lead me. I'm sorry. I had a phone call.
Okay. Okay. Why she takes that?
Sorry?
Why? Okay. Are you done with the phone call?
Yeah, no, I'm done. I just dropped it. Sorry. Sorry for
Okay.
that.
No problem. No problem. Continue, please.
Where was I? I was saying, firstly, we do the proposal. I get it. When we
Yes.
receive a cabinet clearance to do the assignment, then we start by doing our own proposal. Thereafter is when we start a mini depth research. Thereafter, we start to identify the stakeholders, relevant stakeholders for our project. And then after that, we still have as we have the stakeholders, we are still doing our own research within the ministry,
Okay.
and thereafter, then we go for public. We call it pizzo. We go for pizzos. It's a public gathering where we ask Basutu. Again, we show them. We do our for data collection. We formulate our questionnaires. And
Okay.
then in Sesotho, of course, in a Sesotho language, because we have a Sotho here, though we have English one, but for Sesotho, that is when we go for our data collection to the villages to inquire from Basotho whether concerning our law that you want to reform, whether we are
Awesome.
in the same page. And then thereafter we come for data entry. Thereafter, or in the midst of that thing, we still have workshop where we have our first workshop where we introduce the issues paper. The issues paper is drafted by our commissioners. Each project has its own commissioner to run with one researcher. So we have a period where we're supposed to go for working for our issues paper to be workshopped, and thereafter is when we do our entries. After we have our stakeholders, remember, in those meetings, and also in when we do the workshop. There we do our comments, and then it's where we start to formulate our questionnaires. Then we go for data collection to Basutu. Thereafter, we come and do the data entry. somewhere we have our reports, or yeah, until we have another, our last workshop is a validation workshop. We still have our stakeholders. Yeah, thereafter, after that we do our report, and then we take it to our boss, being Lesotho Reform Council. Thereafter, it's supposed to go to the to our minister. Then from our minister, I believe it's when it goes to the office of the Parliamentary Council. When everything went well, it's going to be an act. Legal drafters being our OPCM, Office of the Parliamentary Council, those who are changing law into, these are our comments into law. That's where we have the Gazette and the law, all those things.
Thank you very much.
Welcome.
What interests me in all you have said is that there is direct citizens' participation in your
Yes.
law reform process,
Yes.
because the law is made for the citizens.
Yes.
And you go as far as getting them respond to your questionnaire in the different languages, right?
Yes.
The different main ethnic languages. So you now see that at the end of the day, the document you come up with, reformed law or the reviewed law, will be people's law because they participated in it.
Yes.
Their compliance rates will be high because it is seen as their law. Do you get it?
Yes, sir.
That process is different from what we have here. I said that your process is different from what we have here.
Okay.
Because here we do not have direct citizens' participation in our constitution alteration.
Okay.
Even though in our lawmaking process, we have public hearing, which is supposed to be citizens' participation. That is where the committee calls for, that's under second reading, or rather after second reading, the law, the proposed bill is now directed to committee stage. The relevant committee now calls for memorandum from different stakeholders, and they come to present their memorandum or their position paper for or against the law. But the process is different in the sense that when public hearing or memorandum is called for, it is basically civil society organizations and sometimes ministries that go to present a position paper to say, for this ABC reason, we are in support of this law. For ABC reason, we are against this law, or the formulation or enactment of this law. For B reason, we suggest that this clause should read so, 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 and so. We feel that the interest of women is not properly captured. If this law is passed this way, it is going to marginalize or disenfranchise women. It is going to put women out of job. So now these are done by organized civil society groups or ministries, not directly by the citizens, unlike what you have in your place.
Yes.
So you see, what we have done, what we are doing, what I'm doing with you now is comparative analysis. Comparing the law reform process in Nigeria, that of Lesotho.
Sorry, sir.
Yes.
Yes, here our NGOs comes after there's a law. I remember one of the NGOs, it's SheHive, if I'm not mistaken. SheHive came here asking about our new law is counter domestic violence. They said they want to go to the villagers and try to
Sensitize them.
teach them, to sensitize them. Yes, a good way to sensitize them.
Now
So
that is
that
aiding the
in
implementation.
our stakeholders, relevant stakeholders, sometimes I remember in administration of estate, I remember there was a member from LCN. LCN is our civil societies. I remember there was a guy from LCN. I was new here in the commission. So we engaged them, even as the stakeholder, as a relevant stakeholders, while they're still doing our paper. We go with them. But after the law has been passed, one of these citizens came and then said they wanted to make an outreach about that law counter domestic violence to Basutu there in the mountains, in the rural areas, to make them understand what is the law was all about.
Okay. Now that is a different thing altogether. That
Mm-hmm.
is implementation process.
Okay.
So the NGO is helping to sensitize the people, the citizens, on
Yes.
the new law that has been passed and
Yes.
how the citizens are expected to comply with that law.
And how did they feel about that new
Yes.
law? Mm-hmm.
Okay. Oh, is it how they feel about the new law or how they are expected to obey the new law?
I'm not sure. I'm not sure because for
Because
this
there are two different things.
administration of estate, there was a debate between the Basutu people complaining that it's like this law made for the Westerns or something. But I think the law was not yet passed. But it was
Okay.
this debate between the two houses. There was a debate between two. So they were like, so yeah, there was this disagreement between the legislatures and the people, then Basutu.
Okay.
They don't need this law, this kind of law. They are Basutu, they know how they have their own customs and culture, what. I don't know
Okay.
whether there's a Musutu here who can assist me. Maybe I'm talking the negative thing. I'm not sure. Is there any Masutu here who can assist on this administration of law, administration of estates from the Master of the High Court? Is there any
Okay. What
Musutu?
I'm going
Where
to
can he
do,
be?
based on the issue you raised now, we are going to give it as an assignment, not the general assignment of the house that we usually give at the end of the week, but on this particular subject matter, we will want our Basutu colleagues to come back tomorrow and tell us their own process from what
Yeah.
you're saying now. Do you understand? So that we will have a balanced understanding of the process.
Yes. Yes, sir.
So please, if we have Basitu participants, tomorrow's class, we will want to have a feedback from you on the procedure when the citizens engagement is done. What do they usually find out from you people? Or when the NGOs come to sensitize or to engage with citizens, are they
Yes.
coming to sensitize on the need for compliance, or they are coming to ask the feelings of the citizens regarding the law?
Yes.
Because two different things and
Mm.
their purposes and outcomes are two different things.
Mm.
Thank you very much, madam, for enriching our knowledge.
You're
We are
welcome.
good thing you joined us at the perfect time, because this is your office that we are discussing today or this week.
Yes, sir.
Yes.
Thank you. You're welcome, sir.
Your resourcefulness is hugely appreciated. and we will still engage you more tomorrow throughout this week on this subject matter. Thank you.
Yes, but tomorrow I'm not sure whether I'll be able. I have to attend a workshop, but I'll see during lunch hour whether I can get a place to be.
No problem.
I'll try.
Join us tomorrow. We still have Wednesday, Thursday, and Friday. The whole of this week, we are discussing law reform.
Okay,
the whole of this week.
Thank you very much, sir. Okay.
Okay, so any other question or contribution? Any other question? Okay, I said my own question is this. What we discussed, I said ideally is what ought to be. This is the standard procedure. But for us here in Nigeria, do we follow this procedure? Particularly issues of data collection, issues of engaging professionals, consultation with legal practitioners. If we are consulting, which class of legal practitioners are we consulting? Those in litigation, those in corporate practice, those in politics, those in the NGO space, or those in legislative drafting, because these different areas of practice, we color the response you give. The legal practitioner in the NGO space, we give a perspective from the development world, particularly if they are working on a donor-funded project. The interest of the donor is going to color their response. So bear that at the back of your mind. That if you are engaging with CSO, even when they come to present position paper or their memorandum, what determines their position primarily is the funder, the person giving money to the organization to carry out a particular intervention or a particular project. So if that project has to do with or at the moment of their project, you are bringing up a bill or a review process, they have to go back to the terms of reference of the funder for the project to see whether the funder's position is in favor of the proposal or against the proposal. So they are not taking independent position as an organization. I need us to understand that their position is most times colored by the view or position of the funder. So if you are engaging, you need to have this at the back of your mind, that this interest that is being pushed, this is where it is coming from. If you are also engaging with professionals from the political perspective, you will need to understand that their position will be colored by their party. Are they the party in power? Are they opposition party? Are there maybe a minority party? So those are things you need to consider. Beyond the person speaking, find out what is driving this position. So you do not just take that position on a surface value. On a surface value, okay, this is what NGOA said. Then probe a little further. For this project, who is funding NGOA? So what is the position of the funder on this matter? That will guide you in having a balanced debate, meaning you will need to also probe their own position. If they are saying this, why do you think this? Why do you think this? Shake it. If it stands the test of time, we talked about objectivity when we discussed our 8 principles of research. So the principle of objectivity must run through everything you are doing as far as legislative drafting or law reform is concerned. So any paper, any proposition that comes before you, you must test the principle of objectivity. If you do not do that, at the end of the day, you'll be making a law that is serving a particular sect or a particular interest, different from the interest of the generality of Nigerians or your country, as the case may be. So I felt it's important to bring that to the fore. Then, issue of engagement, citizens' engagement in the UK. If you thought that's impact assessment, rather, in the UK, when they are passing law, in fact, at the bill stage, before you submit your bill, you must have done a referendum, doing an impact assessment, and the forms, the questionnaire you gave people and they filled, you attach it to the bill before presenting it. It has to come with your bill for the people to say, yes, this law, we support it, or this law, we do not support it, because this is the impact it is going to have on our society, on our community, on our children, on our economy, on our business, on our everyday living. So impact assessment is already an integral part of their lawmaking process, not just law reform, but we have not gotten to that stage. We are still developing. However, we have our own, I wouldn't call it the equivalent, but it is better than nothing, our own compendium of financial estimates. But it only applies when you are dealing with bills that seek to establish government agency. That is when it applies, meaning that you have to attach to your bill the financial cost, the 1 year financial implication of establishing that government agency. You have to attach it to your bill. So in practice, you see that what we have discussed is the ideal, but when it comes to practice, we still have a lot of missing gap that we need to bridge by way of insisting that due process and right procedure be followed. Until we do that, we will only be producing laws that we may find difficult to implement along the line. Until we begin to engage citizens directly, even though we are practicing representative democracy, the citizens are already represented at the National Assembly and the houses of and the Senate. However, if we have a way of engaging them directly in the law to see the impact of the law on them, we removed subsidy on the 29th of May 2023. We did not do impact assessments before taking that step. And there was a direct impact on every aspect of the economy. Transportation fare skyrocketed, prices of goods and services skyrocketed, house rents skyrocketed, everything because we did not do impact assessment. If we did impact assessment and now have an idea of what the impact will look like, we will now make a proposal of how to cushion the effect. Not that there will be no impact, there will be impact, but we now cushion the effect of the impact on the people because the law is made for them. So, any other question before we come to the end of today's class? Any other? Okay, Mr. Vincent, you have the floor, sir. Kindly ask your question.
Okay. Good afternoon, sir.
Good afternoon, my brother.
My own question is not a question actually. It's just reference to the lecture of last week. We are given an assignment on Friday to draft
Yes,
an
sir.
enactment course. So I wouldn't know if there is a room to look at what people have done. If
Yes,
that
have you
can maybe.
submitted your assignments?
Well, I started lesson last week, so I wouldn't know if there is a procedure for submitting. I have not done that.
Okay, so submit it to Professor Jaja. You're on the platform, right? You're on the WhatsApp platform, right?
Yes, sir.
Okay, so submit it to Prof. Submit your assignment to Prof.
Thank you, sir.
You're welcome. Okay, Madam Lungile, yes, your hand is up.
Yes, sir. It's not a question to hear on this side. I wonder if is it possible for us to have something written for the assignment now, since it's my first time to be on this group. Yeah, is it possible to have a written document for us for
To
our
go through.
assignment to go
Yes.
through,
Okay.
please?
There is a deload of materials. What is going to happen? You drop your phone number. You are on the Lesotho group, right? You're on the Lesotho WhatsApp group. Hello, madam. Hello, Madam Lungile.
Hello, Ndade. I was
Are
asking
you?
Dr. Jaja whether am I in Lesotho group with Dr. Jaja? Sorry?
Prof,
I
your mic
can't
is
hear
muted,
you,
sir.
Doctor.
Your mic is muted, sir.
Okay, you are in the Lesotho group.
Okay, so
Okay, thank you very much.
we have been posting materials there, and we are posting a lot
Okay.
of materials on the Nigerian group. For the benefit of those of you that just joined, we are going to share some of the materials, may not be all, but some of the materials in the previous topic, on the previous topics we have dealt with for your consumption and reading up. Like I said, in 3 weeks' time, we will be starting the class all over again from the beginning. And we start sharing the materials again on each of the topics. So going forward, I would suggest that you just flow with the tide. This week, we've shared materials for today. We will still share more on this topic. Next week, we share materials for next week and the one of the last week. Then in 3 weeks' time, when we are starting all over again, we begin from the history of legislative drafting and start sharing materials all over again. So I will just suggest for your that you be patient and flow with the tide. You have lost nothing so far. So regarding your assignment, since you joined this week, uh, follow the class through this week, then do the assignment for this week. Do not bother doing the previous assignments. You were not in the class. So as we flow, the weeks you joined, you do the assignment for the week.
Okay, sir. Thank you very much.
Thank you very much. Thank you. Okay, gentlemen, in the absence of any other question or contribution, we have come to the end of today's lecture. See you all in class tomorrow. The class starts 12 noon Nigerian time, which is 1 p.m. Lesotho time. Please endeavor to join the class early so that we can start early and also close early. The lecture is just 1 hour, but we have overshot our time today because a lot of us did not join the class on time. Thank you very much. Do have a restful and productive remaining part of the day. Goodbye, everyone. See you tomorrow.
Goodbye. Same to you.
Bye,
Bye,
sir.
guys.